So welcome all. I'm Hanan Melcer. I teach here. I do all my research work on time. It's an incredible honor and pleasure to have the benefit of the insight and wisdom of Justice Hanan Melcer of the Israeli Supreme Court. Justice Melcer started as an academic, as a lecturer, had a major practice as a practitioner, and has been a justice of the Supreme Court and now the deputy president of the Supreme Court of Israel. He is also, for the last 2.5 years, the chairman of Israel's Central Election Commission, which runs very differently. But as a practical matter, it meant that he ran as an administrator a major election organization system. He was he was the sole legal decider on questions of election law as things rolled out. And as we'll hear today, Israel, which went through 2 election cycles in 2019, really saw everything we saw in our election cycles, and then some and much that we will likely see in the next few years. And to have someone who was in the thick of it, to have someone who, as we'll hear, had the judicial courage to face a very powerful prime minister and a very powerful governing party, and not always vote for them, is an inspiration and a symbol to us here doing law and thinking about the possibility of law offering a genuinely independent check on political systems. So we're enormously grateful that you made the trip and are willing to speak to us and help us learn, to see a little bit into our own future through your recent past. And commenting on Justice Melcer's proposal and embellishing it, we have Professor Elkin-Koren from Haifa University, who the former dean, one of the leading technology and law people I know, and we all know, and who will give a little bit more background and detail on this whole system, and then we'll open up for conversation. So again, Justice Melcer, thank you very much, and please do join.
Professor Benkler, distinguished participants, and esteemed guests, it is my honor to be here today and to speak to you, and I thank you very much for the invitation and for the attendance. I decided to dedicate this lecture today in the memory of Chief Justice Meir Shamgar, who passed away on last Friday, and his funeral was held yesterday. Obviously, I could not attend, but I cherish his legacy. He was a legal giant and the master of national security law, which is connected to the issues that we will discuss today. So let's God and we cherish his memory. Now, before I start my lecture, I have a warning point. Whatever I'll say here is not as a representative of the Supreme Court or of the Central Election Committee. And as a matter of fact, whatever I'll tell you is not necessarily even binding me. And I'll tell you a story about that, a real story. Before I was Justice of the Supreme Court, I had a law firm and I argued many cases before the Supreme Court. And once I had a court case, and it was before the Chief Justice Aharon Barak. And I told my client that we are going, hopefully, to win the case, because I found an article of Professor Aharon Barak when he was in academia, and I based my argument on his article, and his article really was in our favor. And then we came to before the court, and Professor Barak, who read all the written material that I presented to him, said, you know, you quote a lot paragraphs of my article. I wrote it about 15 years ago, and in the meantime, I have changed my mind. You know, you can understand that, you know, I lost all the blood and went from my head to my feet. And then he made another statement. He said, you have the chance to persuade me that my previous understanding of the matter was right and not my existing view. So really, I tried, and successfully I succeeded. But you have to understand that if any issue will come before me and a new argument that I didn't think about will come up, I'm not bound by my own ideas here. Now, as a matter of fact, in 2019, about 50% of the democratic world and the quasi-democratic world went for elections. Just take India, which is more than 1 billion people, Canada, that we had elections at the end of this weekend, Brazil, all the European countries for the European Parliament, Switzerland last week, and in Israel twice. And as you know, in Israel, the first elections, which were held on April, were held on April because the Prime Minister decided to call for early elections. And then he couldn't form the government, so he called for another election. So we had two election campaigns and elections in Israel just in 2019. Now I have to tell you that due to the fact that in 2019 there was, okay, I'm sorry, that due to the fact that in 2019, if you don't hear, I will speak up. We had two elections, but the first one was in April. In all those issues that I speak today about, we were probably the first one to have those elections, and that is why all the world looked at what is going on our issues in Israel, and from then, and whatever we did was a precedent for other countries in the world. So it just happened like that. Now, as I see here, many familiar faces in the closed session that we had from the morning, I have had to explain the electoral system in Israel, but I see that there are many, many Israelis here, so I don't have to describe the Israeli election system in Israel. And besides that, Professor Benkler has asked me to go right into the examples that I talked about in the closed session. So your request is my command, and I'll go just to the point. And I'll try to describe you part of my experience in handling two election campaigns in Israel. By the way, it's a precedent that a Supreme Court justice is handling two election campaigns, but because there was such a small difference in time between the one election and the other one, I was re-elected by the justices of the Supreme Court to run the second elections as well as the first one. And I declared after the elections that if there'll be a third round, I'm not going to do it anymore. So everyone has to know when to retire. So I made that declaration. Now, what I'll do, I'll try to describe you 4 decisions of me in my capacity as the chairman of the Central Election Committee of Israel. And as a matter of fact, you have to understand, as a chairman of the Central Election Committee, I have 3 basic functions. One is to be the, let's say, the chairman of the committee, and it was decided by the founding fathers when the State of Israel was established that the Supreme Court justice who will be chosen by all members of the Supreme Court will chair the Central Election Committee, due to the fact that the founding fathers couldn't agree on any other person to chair that Central Election Committee, and so it goes on from the moment the State of Israel was established in 1948. So the first function is to be the chairman of the Central Election Committee, and in this capacity, I have I'm functioning as the chairman of a board, and the board is the committee, which is composed of 34 representatives of all existing parties in the Knesset. Then, I have also a CEO and a very small staff that regularly is composed of about 30 people, but once elections are declared, it goes up, and at the end, at the day of the elections, we employ altogether 100,000 people. You have to understand, 100,000 people, if you compare it to any other action, there's not any other action so huge in the civil life of Israel, and you just can't compare it to the army, and it's very much like to operate about 5 divisions or 3 corps, or 5, 6 divisions and 3 corps. So, and then on this function, I'm doing the job of the chief of staff. Now, the second function is to decide on all legal matters, and there I have to decide on those matters exclusively, because all the other members of the committee are political members, and they are represent parties. So on those matters, I decide exclusively. Of course, any decision that I make can be attacked in the Supreme Court, and people and parties are using this possibility. I hope, as a matter of fact, in those 2 elections, there were many petitions against me, but none of the petition was accepted. Again, it's a precedent, because in all the previous elections, some of the petitions were accepted. So that's another precedent. Then the third function, which is a new function, and it is a lesson of what happened in the United States in the 2000 2016 elections and in other places in the world, is to try to stop foreign intervention and to deal with and to handle with propaganda over the social networks. So the third function was something that never ever occurred in the past, and it was a new challenge that I had to struggle with. Now I devoted my time, about 50% to the administrative functions, about 25% to the judicial functions, and 25% to the security matters. And you have to understand that at the beginning, I couldn't even tell anyone that I'm working on the security matters. So I was sitting in the court as regularly, and in the late afternoons and in night, overnight, I sat with all the security and the intelligence agencies to prepare ourselves for the third mission. Just after the elections were declared, then in a mutual decision with the security agencies, we published a notice to the public about that. Now, in any case, I'm not going to go into details about the security matters from obvious reasons, but what I will do, I'll describe 4 decisions of the 2 elections. 3 of them are from the first election campaign and the 4th one of the last election campaign. And then after you'll hear comments from Professor Niva Elkin-Koren, which helped me a lot to understand the new era of social networks and the involvement of the security organizations. And really, she is the expert in Israel. So I consulted many people, but she helped me a lot in those matters, and I thank her for that. So she will make comments, and Professor Benkler will make comments, and then I'll take your questions. I tell you right from the beginning that I'll listen to all your questions, but some of the questions I'm not sure I'll be able to answer. Not that I will not be able to answer, but you can understand that if you will ask me 2 delicate questions, I apologize that you will have to understand that I can't answer those questions. Okay, now I'm coming to the first case. The first case was in the first election, and there you have to understand we have a propaganda law which was enacted in 1959, and it covers many topics which were very innovative in the late 50s and 60s, but it doesn't cover at all the social networks. Then no one even dreamt about the internet. Okay, so before the elections were declared, there was an initiative in the Knesset, in the parliament, to apply the propaganda law of 1959 to the social networks. Some of the parties really were willing to have this provision, to pass this provision. Some of them were neutral, but the Likud party blocked the initiative. So after the elections were declared, a lawyer and an NGO filed a petition to me, asking me to judicially decide that the election, the provisions of the existing law will apply to social networks. And in the existing law, there is a provision saying that in the period of the elections, no ad can be published anonymously, but you should, in every ad, in billboards and in the newspapers, you should say who stands behind the ad. So the petition said that I should apply this provision into on the social networks. Now I made a hearing, and as a matter of fact, it was almost I was almost ready to dismiss it because it was theoretical. There was no any actual case before me. But then, you know, I say sometimes that everyone has to have his luck. After just a day after the hearing, and suddenly, on all billboards in Israel, there was an anonymous ad saying in the ad there were 4 very famous journalists with their faces and their names, saying, you, the voter, have to decide. Who will decide for you? Those 4 journalists or you, the voter? Okay? And it was published anonymously. Now, the same ad was published in the social networks, just the same ad. And then the petitioners who understood that in the hearing they didn't have any hard facts to base on their petition, asked for to correct their original petition, and I decided to have another hearing. And in this hearing, the Likud party had raised 2 arguments. First of all, they said, oh, in the meanwhile, the press tried to find out who stands behind the ads, and they found that behind the ads, the Likud was standing. And then the Likud said in the second hearing, okay, we made a mistake. It was by mistake. It wasn't published who stands behind the ads. We will leave it on the billboards with the name of the Likud, but in the social networks, we will in the social networks, we are allowed to go anonymously this time and in the future occasions as well. Then I heard all the arguments, and then I issued a decision saying that I issued an injunction saying that this special case is an example of the need to apply it also on social networks. Now, I gave, as a matter of fact, basically 4 arguments. The first one was I based my decision on the theory or the principle of defensive democracy. Then I used the technique of purposive interpretation. I found another provision that in the 59 law that in a purposive interpretation I could apply to such a situation. And then I used what is called we have a law that is not used so much. It's called the law for fundamentals of the Israeli law. And it says that if there is a question comes before a court or another judicial form, and there is no answer either in law or in the precedent of the Supreme Court, you can use either analogy, and if there is no analogy, you can go to the roots of the Jewish tradition and Jewish law, the ancient Jewish law. So I said, okay, there's no specific law, there is no precedent, but the analogy here is very clear because it's just the same ad in the billboards and in the social networks. And even if you'll say that there's no analogy, I found roots in a very creative manner. I found roots in the ancient Jewish law. And so I covered myself in all alternatives, and I did it because I was afraid that the Likud will try to attack my decision in the Supreme Court sitting as High Court of Justice, but they didn't. And then, so we had a decision that was binding on all the parties. And then my friends in the academia said, okay, it's a very sophisticated and very nice decision, but you'll not be able to implement it. What they didn't know, that in parallel, in my administrative capacity, I spoke, they asked me to say that I spoke with them, but as a matter of fact, I negotiated with Facebook, and I told them that in such cases, they should do something. And the reason for them to do something is their declaration to the US Congress that they will apply, let's say, new techniques after what happened with Cambridge Analytica. So I called them for a meeting, and I asked them to show me and they would apply it not just in the United States, but all over the world. So I called them for a meeting. They came over from the United States, very high-rank officials of Facebook. And then at the beginning, they were very polite, but not responsive. And then I told them that there is another alternative, that if such a case would arise, we'll go by the legal path. And I don't know whether it's advisable from their point of view. Okay, so they asked for several days to think it over, and then they came with a proposed solution saying that they are willing to apply their procedure of notice and takedown on such matters. And then I said, okay, I really appreciate your declaration, but it's not enough. Why it's not enough? What will happen if someone will give a notice and you will not decide to take it down? So they asked me, okay, what you ask us for? So I said, if such a person or a party will use the procedure of notice and take down, and you will refuse to take it down, then he can make a petition to our committee, to me, and if I will issue an injunction, you will have to adhere to it. Took another several days, and then they said, okay, we agree. And from then on, I must tell you that at the beginning, as I told you, they were not so responsive, but after those 2 weeks they called it talks. And after that, again, it's not an agreement, but understanding, it went very well. And you have to understand that after that decision and the procedure of notice and takedown, and in some cases appeal that was before me, about 70% of the anonymous material in the networks went down. Here I have to emphasize another point. Our security organizations allowed me to put in the decision a provision saying that it will be much easier for them to monitor the possibility of foreign interference if no local party will use anonymous advertisement or any anonymous publication. So I put it in with their permission in the decision. And as I tell you, it was a success because then all the security organizations could deal with the other 30% and with some of the local parties or local initiatives that didn't adhere to the decision. But it made it much, much easier. After I spoke with Facebook, I went to Google and I went to Twitter, and I let's say, came to a similar understanding with them as well. So we covered most of the social networks. Not all of them, but most of them. The major ones. So that was the first decision that I wanted to describe to you. Just afterwards, we had another petition. You know, the problem, and again, here I want to add something to the students who are familiar with US legal work on those matters. I didn't know at that time that a very similar idea was introduced by the late Senator John McCain in what is known as the Honest Ads Act. But it didn't become. It was just a proposal. He made the proposal with two other senators, and at that time I thought that I invented something, but then I didn't know that such a thing was being proposed in the United States. Afterwards, I read the book of Professor Benkler, and he mentioned that there. So I saw that I wasn't the first one in the world to think about such an idea. But still, I was the first one to issue such an injunction because, again, the law or the act that the late Senator John McCain proposed didn't become a law in the United States. Okay, now I'm coming to the second case. The second case came before me just after the first one, and the facts were like that. One of the parties, a small party, then it was a small party, Israel Beitenu, then it was a small party. They said that over the cellular phones, a poll is being distributed, and you have to understand regularly polls are being distributed to 1,000 or 2,000 people who have to answer or are being asked to answer. In this case, about 50,000 people got the proposed or the poll, which was anonymous, and the main thing was it was anonymous, and in the possibilities to answer the poll, this party, Israel Beitenu, was not included. And then they said, first of all, it is against your decision because it is anonymous. Secondly, the idea, and to send it to 40,000 or 50,000 people, the main idea is to, and it was targeted to people who the initiative was targeted to those people who thought whether to vote for Israel Beitenu or not. And once not including this party in the poll gives a hint as if they were not past the the threshold of 3.25% of the vote, which give you the chance to go into the parliament. Okay, I issued immediately an injunction, but then Israel Beitenu said it's not enough. We want to know who stood beyond this poll. And I made another hearing, and then you have to understand it was with cellular companies, and according to the cellular companies in Israel have license, and they are not allowed to permit anonymous, according to the license, anonymous distribution of messages. So, and if they breach or infringe this provision in the license, they could lose their license, but that is not enough. If they act according to the license, they have an immunity which is similar to paragraph 230 of the American Communication Decency Act. So I told them, you should tell us who stood beyond the poll. And then they understood that they might lose their license and they might lose their immunity. So they said, okay, we are willing to disclose. And they asked the one that has initiated it, and he said, okay, I don't have any way to not to disclose it, and he gave, I don't know why, but he gave his acceptance to the disclosure. But then, probably that was the reason, it was the first year. As a matter of fact, it took another 2 years to come to the original initial term. And at the end of the day, you wouldn't believe who was standing behind this message and the poll. It was one of the parties that I don't want to comment on that, but was one of the parties that really their claim to fame is their cleanest way of doing politics. And that was the fact. Okay, so that was the second case. The third case was, never mind, afterwards I'll tell you because you're so interested. The Israelis are interested, but that was the case. The third case came before me after a joint venture between the New York Times and the most popular newspaper in Israel, Yediot Achronot. And it was a piece of investigatory journalist investigation, and they said that the Likud is behind NetBot, and the whole investigation, or the whole article was called the Big Bot Network. Okay, as a matter of fact, it wasn't. By the way, it wasn't a bot at all. It was how do you call it? Soap puppet. Soap puppet. Okay, that there were really real people who didn't disclose their names, and immediately after the publication of that piece in the papers, one of the big parties, Kahol Lavan, which today their leader got the formal mandate to try to form a government, they filed a petition without adding anything to what was in the paper, but just giving me the article and asking me to issue an injunction because it was, they had two claims. First of all, because it was anonymous, the network was anonymous in a way, and they claimed that there was a conspiracy. Here, they didn't add anything to what was in the papers, and beside that, to base legal action on what is written in the paper, it's also a problem. So in that case, I decided in favor of the Likud, saying that they didn't establish a conspiracy, and that is very similar to what the Mueller report said about what happened in the United States, that no conspiracy had been proven in the level that is needed for legal action. However, I quoted a verse from the prophet Amos saying, "Can two walk together except they be agreed?" And "Halchu shnayim yachdav bilti no'ad." But still, they couldn't prove more than they couldn't prove what they claimed. So I dismissed the case. The fourth decision was in the last elections, and here there was we have a provision in the existing law saying that in the last 3 days before the elections, no polls should be published in any media and by any party. Now, the Likud and the Prime Minister Netanyahu, they used chatbot, and in this chatbot, and the chatbot was activated by Facebook Messenger, and in those, it was within the 3 days, and they published in this chatbot a poll saying that the Likud is going to lose the elections, and the liberals and the leftists, as they called it, are going to win. So they call all Likud supporters to go and to vote. Now they put in the board the poll that they wanted everybody to see, and it was within those 3 days. So a day before the elections, a petition was filed to me, and I gave at the night at 10 o'clock p.m. an interim injunction telling them that they should take down this publication up to 7 o'clock in the morning, the day of the election. And I issued the injunction against the Likud and against Facebook. Then, due to the fact that we got, after what I described before, good connections with Facebook, Facebook called my legal department saying that they think that there was a mistake, that I issued the injunction against them as well. And then I told my legal department that if they have any problem, they should file a petition to me. I'm not going to speak with them informally on this matter. So in the morning, they filed a petition and asking me to correct the decision, saying that it was probably I issued the injunction against them by mistake. Besides that, the Likud have issued a response, and they have raised two arguments. One was that it's not a poll, it's a fake poll. So if it's a fake poll, it's not a poll. And the second argument was that that they are willing, they understand that if the first argument will not be accepted, they are willing to pay a fine according to contempt of court. But and they are willing to pay a fine and even a very huge fine. Okay. And then while the injunction was enforced. And then while I'm considering and writing it was you have to understand, in the election day, while I was writing the decision, suddenly the representative of the Likud in the election committee came over and said, we have an idea. And then I said, okay, you have to put it down. And then Facebook came to me as well, and they said that the Prime Minister and the Likud are saying that they are willing to take it down, but there is a problem. They cannot differ between the illegal publication of the poll to the legal matter that is allowed to be published on the bot chat. So I said, if that is the case, just take down the whole bot chat. And then I asked the Facebook if they are willing to get a decision or they want to withdraw their petition to change my decision. And then they said, okay, now we will do it by our initiative. And then suddenly the Likud found a way to differ between the polls and that were illegal published and the other material. In the meanwhile, the bot was down for 3 hours. And then when the Likud made the undertaking that they will differ and will take out the poll out of their chat, then the Prime Minister made an interview saying that he doesn't understand why I decided as I decided, because he was willing to pay a very high fine in contempt of court, and how I dare to put their bot down in the day of the elections. So then it wasn't allowed to make any interview at the day of the election. So I said, now you have to add another provision in your undertaking that you will not make any interviews anymore. And they accepted, and then I was willing to allow them to put the bot up again. But then Facebook said, okay, we have to get direction from the United States whether to put it up again. So it took another hour, and then they came to me and asked for a formal decision. I gave a formal decision, and then the vote went up, and there were no more interviews and no more polls. Those are the 4 decisions that I wanted to describe to you. And I want to say at the end, before opening to comments and questions, that as you see, in this case, in those matters, the light onto the nations came from Jerusalem. Thank you.
So thank you so much. Thank you so much. As Neva comes up and is preparing to speak, just in case you didn't notice, through the extremely mild manner with which the justice presented, he described the situation where he pushed back and forth between his administrative capacity and his judicial capacity to reach an accommodation with Facebook and then Google and Twitter to do informal, unordered implementation of what are essentially ordered. He threatened to take away immunity from the cell companies if they didn't reveal enough to allow to have enforcement against individuals. And he ended up enjoining the sitting prime minister from using a chatbot over Facebook Messenger and targeted. So there's each of these three could occupy a seminar of controversial relations between private and public, between judicial and administrative. Let's not forget them. And Neva, let's hear from you more about what we're learning from this election system.
So, we're learning about the virtues of law, but also what can happen at the shadow of law. And I think that this is a story about what is happening when the law or the politicians, the legislators, cannot regulate politics and elections because they're involved and they engage in it. And I think that the question for me, and I think that should be the question for us, is what does it take to save our democracy and our elections when the politicians are not functioning? And I would say that it takes a village, and the village is made of the judiciary and the social media and the media and civil society. And I'd like to show you that really briefly by going back to the stories that we heard about and just flesh out some of the functions of each of the players in each of these stories, or at least in three of the stories that we just heard. So in the first round, it took courageous justice to take this decision that would apply the law of the elections to the social media arena. But then it also took some work from civil society, the media, and also social media. So we've heard about the collaboration by social media that they undertook upon themselves to collaborate and to take down. But there were other players here as well. So one of the players was civil society. So we had groups of people working with, collaboration, coalition of NGOs that were actually looking for bots, actually calling the public to report bots, reporting them, tracking them, going to social media and asking social media to take them down. Some of these bots were actually bots. Some we've heard were actually real people. And what was really interesting here is that we heard from Justice Melcer that this was reported in the Israeli newspaper, in the New York Times, that this person, this fake profile, would turn to be a real person, was actually endorsed by the prime minister, that actually turned this story into a story of success for the Likud party, where Netanyahu was actually turning it into a spin on April 9th, that is the election days. The boss, we, the party, the Likud party, will go to vote, and we're all boss. We're all going to vote and actually elect the right party. So it's not only about what you do in social media, but actually how you turn these stories sometimes in your favor. So this was not a success story for civil society or for journalists or investigative journalists that were doing this story. But in retrospect, post-mortem for this, and we're looking at what happened in the Israeli society during the first elections. And I think that this is one lesson that we had, that even though there was a spin, there was no success in terms of identifying bots, but the bigger picture was that we've gained some digital literacy and the ability of, the awareness of people over some of the dangers that you're facing in social media. So when my 85 years old mother said to me, I've seen this on social media, is this a bot? And so I thought, this is great. This is a great success, and maybe this is something to be gained from that. Second round of the elections, we had a story that actually did not involve the judiciary. So we had social media, civil society, and the media, when our prime minister actually reported was sharing hate speech online, and his chatbot was actually blocked by Facebook because this was a violation of Facebook community guidelines. And that's an interesting story that actually did not involve the judiciary, but involved other courageous people in civil society. So here you have, those of you interested in this story, it is documented here. You can just, this is like 10 pages that are actually describing, what was happening here. But here you had an activist lawyer and an activist media scholar. And Hanan David was actually studying the way in which the chatbot was actually working online, and that was doing something that was really interesting. And so taking the voters list that you get from the elections committee, all the parties get the voters list, using social media, in this case Facebook, through advertising, in order to classify that group of, the list of the voters, to those who are for us and those who are against us, who is going to vote for us. So the chatbot would do some games in the beginning, and then engage people in a lot of activities. And at one point would ask, are you going to vote for me? I'm the prime minister. And so enabling this type of classification, and then using the chatbot in order to activate the group of supporters and actually recruiting them to engage more and more people in this type of debate. This was something that was happening using the messenger, but the social scientist that was using a lot of fake accounts in order to document this type of activity managed to pretend to be an activist that is loyal, that is supporting the Likud party, and therefore receive that hate speech from the chatbot. The hate speech was not announced by the media. It was not announced in television. It was only communicated through the messenger to the people who were loyal, right, and received that message. This was leaked to the media, like public media. The media reported it, and only after it was reported by the media and created some awareness in the general public, Facebook took action against this and actually blocked the chatbot for the first time for 6 hours. So this is a story that involved social media, civil society, the mass media, but no judiciary intervention. The third story that we've heard about is actually quite remarkable, right? I mean, this is like a prime minister of a country, and the chatbot is being blocked on election day by a this is a chatbot that is actually being used most intensively on election day in order to manage some of the activities on the ground during very critical time. And here, as we've heard, we actually had, again, we had, of course, the judiciary, but also some action by civil society, social media, and the media. And the reason is that, again, these type of polls only showed up, or the illegal polls only showed up on the messenger, communicating the polls to this selected group that was the loyal group, or identified as loyal group, and showed up on the screen of Hanan Melcer, the researcher that was holding all these fake accounts and was collecting this information. The petition was brought in by the activist lawyer, and this was, and it took the creativity and innovation of all of these players in order to come up with this order. But this was also perceived, in a political direction, right, by the prime minister or and his supporters as a form of stealing the elections, right, and trying to circumvent the fair play by actually taking an extreme action. So, last thing that I want to mention before I go quickly to my takeaways from this is that the use of the messenger, I think, is something that is really important and is really different from the type of misinformation that we've seen in the 2016 election. And that is something that is really taking us beyond misinformation and disinformation into creating a new way of governing and communicating with people in a secretive way that is not open to the public. So if we were talking about, we normally talk about public ordering on one side, right? When governments are actually working as government, or private ordering, that is something that the type of governance that is being done by companies. Here we start to think about some sort of mass personalized ordering, and that is the ability to activate people without a lot of people, like a lot of crowds, but to do that directly with each of them individually, so we don't know that we all get these directives or orders. And again, those of you who are interested in that story is posted online, how that messenger was working, what type of orders it was giving, and these were like, Yalla, Prime Minister, I'm ready. That was a button that you had to push whenever you got a new, if you wanted to get a new assignment. So what are the takeaways? Civil society, to regain our democracy or protect our democracy requires some courageous activists, but also some innovative methodologies, such as methodologies that would tinker with the things that are being done by politicians using social media. And also lawyers that would actively undertake these petitions and lawsuits and bring it to court. It does take the involvement of the general media, the mass media, things that were kept secret. For instance, the hate speech that was communicated in the messenger did not get any attention before the media actually published them and created a lot of pressure on Facebook that eventually, 48 hours after it was posted, blocked the chatbot in the case that did not involve the judiciary. And of course, it requires a courageous judiciary that would use doctrines such as defensive democracy opportunity to expand some of the laws that apply to mass media and extend them also to social media, thereby creating a new regime. But I think that this is something that could also be dangerous in the sense that as those of us that live in liberal democracy are facing a constitutional crisis anywhere, right? I mean, it's like all of us are opening the newspapers and we see a constitutional crisis in the United Kingdom, in the United States. We also have our own part of this in Israel. This is a heavy burden on the judiciary. The judiciary cannot save us when we disagree on very fundamental issues. So creativity and innovation is good enough in order to use an existing law and extend it to social media, but then someone has to work out the details of how it works, right? When do you remove things that are anonymous and when do you not? And so I think that when we come to think about social media, I think that the 2 rounds of elections in terms of attacks and manipulation on social media were a big success, but I think in Israel, but I think that self-regulation of social media is insufficient. I see your eyes face. We are running out of time, so I'll stop here. There are more questions. More questions
Be quite so expressive, sorry. Let's open up for questions. There's some genuinely, actually, Justice Melcer, can we have him come and sit here and Professor sit here as well. So questions, yeah.
Thank you guys so much for your talks. They're very, very interesting. I have 2 sort of small questions. Number one, just also when you were talking about your conversation with Facebook and like sort of applying the notice of takedown to Israel, did the conversation? I know that Facebook policies in light of Cambridge Analytica also included requirements for political ads to have like a disclaimer of who was. So that also was part of the conversation that you were talking to Facebook about having that apply. Okay.
Yeah, that's right.
And then
I didn't describe all the talks, but it included.
Okay. And the second thing is, in light of the instances, the examples that both of you gave, one thing that sort of came to mind is how WhatsApp is also sort of like an influential platform. It's not like a typical social media platform, but that how information floats around Israel through WhatsApp. So, for example, the photo you were talking about, how you could get the photo on like Likud on Facebook to say that it was them, but the photo could still be shared around.
Okay, I'll just answer a very short answer. The fact that the groups in WhatsApp were limited, I have also a share in it. I don't know whether you're familiar with the fact that the groups in WhatsApp were limited now, are limited now, especially in election period.
Right.
Okay, so you have an answer.
As other people are raising hands, I'd actually like to ask you a question, Justice Melcer. You describe a process that is conflict of a certain kind, a little bit of arm wrestling with the companies, but that the outcome as you describe it, you think of as positive. Essentially, the firms did what they were good at, you did what you were good at. Do you have any thoughts if you were writing a new Honest Ads Act for us? What's the lesson? Because it's not private ordering and public ordering. It's a very distinct public-private partnership where you're taking certain responsibilities. The companies are the only ones who can take others. What would be an ideal model from your experience if we were writing an Honest Ads Act for ourselves now?
First of all, to be quite frank with you, there is no an ideal model, but we went too far with all those big companies like Facebook and Google. So you have to cooperate with them, but still to supervise them. And the model of them taking measures in the first instance is okay, but then it's not the last word because they want to have the last word, and they think of an advisory board or a quasi-judicial board, which will be outside Facebook, but still it will just give recommendations and it will not be binding on Facebook. So I think that the two-tier mechanism will work, but here it's not just that you can do the honest act, but you have to implement some mechanism of deciding on a judge that will decide on those matters very quickly. And here, because of your system, it's very difficult to find such a judge that is agreed upon between the two major parties. So, but you can do it. Now, Professor Kahana wrote the book, thinking slow and fast, or fast and slow, as a matter of fact. So you have to have, because the decisions here have to be very, very quick. So first of all, let's say the basic, because I saw it later on, the basic idea on the merits of the initiative of the late John McCain was good on the merits. But then you have to add in it two more things. First of all, time limit, and secondly, you have to find, let's say, judges in every state who will be agreed upon between first of all, the parties, and then that they will be the court of appeal of the decisions of the companies like Facebook and Google, and whatever they will decide will be binding. Of course, later on, ex post facto, you will be able to go to court in the bottom up on the let's say principal matters till the Supreme Court of the United States. But you have to add in this act, proposed act, the essence is okay, but you have to add a mechanism to decide.
Thank you all very much for this. So some of the things you need to adjudicate are very visible, right? You can see if something comes out, but below the surface, there's a lot of activity like fake profiles, or even just ordering of the ads and the information and the posts that we see by other people that has a great impact. And that is sort of less visible and less easy to challenge. And we're sort of trusting Facebook to do that, just like they can block some hate speech. And how do we trust them to make that decision, or how do we look at how they're making that decision in a critical matter, right? So we're talking about regulating the parties, which is a lot of what you did, but what about that more hidden activity, or the activity that Facebook is actually regulating, maybe profiting, or maybe has an agenda? Maybe Facebook supports one of the parties.
Okay, I'll give you an answer. My main theme is that anonymity over social networks should not be allowed in times of elections. Now, and anonymity includes everything. It includes boards, it includes, how do you call it, fake profiles and so forth. But that is the distinction that I made. So if all those anonymity publications, they should not be allowed in times of elections, as long as they are connected, and you can prove that they are connected to any party or any candidate, or they are financed by any party or any candidate. Now, and that is one condition. The other is, of course, if it is, you can prove, and that you should not prove it. It's the job of the security agencies, if you can prove that it is made by a foreign country. So that is not allowed at all. All the other alternatives, and even if it is a publication that uses fake profiles and it's not connected to any party and it's not financed by any party, I would allow it, because I don't want to go, to limit too much free speech and the First Amendment rules you have. In any case, it will not go through the Supreme Court of your country. So you have to adjust yourself to your culture, your legal culture. And by the way, I am a believer of that concept in Israel as well. So there are two exceptions. One, if any such a publication is made by a party or by someone or any group that is connected to a party or any candidate, or it is financed by them. And the second one, if it is initiated by any foreign government. Now, you have to improve your let's say, reporting procedures as far as financing, let's say, elections, and you have to change the decision of your court in Citizens United. Here I support the minority, not the majority. And in Israel, we have laws governing those matters. Here, so you have to make a change in the decision of your Supreme Court. And okay, I don't want to interfere too much here, but I personally prefer the minority, not the majority.
Let me just add to that. It's so fake accounts are allowed on Twitter and bots, and are not allowed on Facebook. And once you have a decision of that sort, that would allow you also to prevent it in other social media that are not implementing policies to prevent the use of bots or fake accounts, and that is by using the rule of law in this situation.
I'm glad, Nita, that you all followed up in that form, because I want to push you a little bit on the role you gave civil society. Mm-hmm. Even in the present system, let alone the system that where Messenger and WhatsApp are important, the civil society activists you're talking about are violating terms of service in order to get the information. Yeah. They have to pretend to be somebody else, exactly the things you want to get on. How sustainable is a strategy that depends on civil society that has to, in the case of academics, quite possibly violate research ethics? In the case of other civil society actors, certainly violate terms of service. Do you really want that?
Absolutely. And the reason is that I think that, in general, I think that is true not just for election time. I think that it's true in general. I think that we should have an exemption for these type of tests and tinkering, because we need access to data and to technology and to algorithms that are regulating us. And if we're not going to have an exemption for that, then we're doomed. I mean, We don't have any access.
So you want a specific legal exemption
Absolutely.
for white hats?
Yes, yes, absolutely. And I think it's important not just in the context of elections, but definitely here, I think it was successful in the sense that it allowed the public to get information that we would never, ever discover otherwise.
I would like to ask you, how would you react to fake boots that are activated from another country, from abroad? Even though Google and Facebook are global companies, it's other thing to react to those fake boots from abroad.
Okay. Here, I'll answer your question with another case that came before me. As I told you that there was an agreed procedure of notice and takedown. And in one of the cases, there was an allegation against one of the members of the Knesset from an Arabic list. And the allegation came up anonymously from Qatar. Now he used the notice and takedown procedure, but from their reasons, Facebook didn't take it down. And then he made a petition to me. And then I had also a problem because it was Qatar. So I told, I made an interim injunction, and I asked Facebook, who is active in Qatar, to tell the one that initiated the publication that he has the right to react on the injunction. But in the meanwhile, I told them to take it down, and they took it down. Immediately, 5 hours later, he opened a new account. Okay, and then I issued another injunction, and then I asked him again to let him know that something like this happened, and he had the right to react. His reaction was that he will sue me in many international forums. Till now, he didn't sue me, and they took it down. And then he made it for the third time. And the third time, then I issued the third injunction. And then I told Facebook that I want them to disclose who is behind that. Then it stopped. Okay, so probably it gives you an answer.
I think we have time for one more.
Thank you so much for that. So I'm visiting here from away, and actually last week in Georgetown University we had the pleasure of hosting Mr. Zuckerberg in the capacity of a student club. I'm an Israeli lawyer, my name is Itai, and in the capacity of the students club that we founded there, the Georgetown Tech Policy Initiative. And I asked him in the closed conversation, I asked him, so Mr. Zuckerberg, who should regulate the internet? Because right, all the questions here are about who really have the ability to regulate the internet, and a lot of the things about the data and sharing the algorithms. And I was fascinated by the fact that you said that you had to negotiate with them, right? Not in the common law way that we act as a state. So what's your response? Who you think should regulate the internet? The government, or it's actually should stay the same way as today? Thank you.
Okay, in the first place, I think that the government or the parliament should regulate as it regulates other markets, but we went too far. And now, if you want to get effective remedies, you should talk to all those companies, but you have to make it very clear that the final decision is not there. So, and they understand it. And if they understand this simple fact, and then an injunction or other remedy is issued against them, then they understand it even better. So that is the way to handle such things.
So thank you. I'm still reeling from the idea that you asked Facebook to create an appeal process for somebody in Qatar for an Israeli decision about takedown. This is sweet beyond belief. No, but seriously, thank you for that kind of creativity, for the courage. We're not going to solve it all here, but thank you for taking the time to teach us, to talk to us. We all have a lot of learning to do together and from each other. Thank you.